from a woman blaming personal tragedy for her failure to follow probation terms.
So counsel, do you believe she's competent?
I believe she understands the nature of the proceedings.
To a man facing assault charges.
All right, you're charged with assault on a process server. That's a third-degree felony. Range of punishment is anywhere from...
Here are 5 moments Judge Boyd ensures offenders are held accountable. Starting with Ms. Roblo, a woman who failed to meet the terms of her community supervision while facing charges for injuring an elderly person.
Court is calling 2022 CR 5436, State of Texas versus Susan Robledo. Could I have parties announced for the record for the state?
Ashley Jones for the state.
Charles Bunk for Susan Robledo.
And are you Ms. Robledo?
Yes.
All right, did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
The reason why
Did you understand what we talked about?
yes.
All right. Are you the same Susanna Robledo who was placed on community supervision in 2022 CR 5436 for the offense of injury to the elderly bodily injury on July 11, 2022 for a term of 7 years? Is that you?
Yes.
All right, state.
Yes, Your Honor. The state is alleging that the defendant violated condition number 4, that in Bexar County, Texas, the defendant, Susanna Robledo, did then and there fail to report to the supervision officer as directed for the months of May, July, and August of 2024 in violation of condition number 4.
Do you plead to that, true or not true?
It was true, Your Honor.
All right. Did you understand, state, are you proceeding on any other allegations?
We are not your way of remaining allegations.
Any
Objections.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, and sentence you up to 7 years in prison and up to $1,000 fine?
Yes, ma'am.
Knowing that, do you wish to still plead true to violation of condition number 4?
Yes, but there was a purpose for
We're gonna get to that. Hold on.
Court then will find violation of condition number 4 true. Is there a proposed agreement?
Your Honor, at this time, we do not have an official agreement. I do believe both defense and state want some sort of mental health treatment. I think the difference is outpatient versus inpatient, and defense, please correct me if I'm incorrect.
That's correct.
Okay,
All
so
right.
the state would be recommending DDRF evaluation.
All right, and defense, what are you requesting?
Judge, my client's been in custody for 90 days. She had a TAP evaluation back in May that recommended outpatient, intensive outpatient mental health treatment. She'd like the opportunity to address the court and kind of discuss what was going on in her world that led to her failing to report. If the court would allow her, I'd like her to be able to address the court. I think she can state better than I can what's been going on in her situation. Ms. Robledo, would you like to address the court?
You want to raise your right hand? You
Yes.
solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record. All right, you're gonna need to speak up so the court reporter can. All right, what did you wish to say to the court?
I just sorry I had lost my mother, and Your Honor, I am a federal agent. Badge number 015266. I almost lost my life due on some case that was going on.
All right, just give me 1 second. So, all right, just 1 second. So counsel, do you believe she's competent?
I believe she understands the nature of the proceedings. She understands the nature of the proceedings and my role in the proceedings. I do believe she would benefit from treatment. My concern is that the wait for the inpatient DDRF is an additional 8 weeks, and she's been in jail for 90 days. So I would just like to get her some mental health treatment sooner rather than later, and I'm just concerned with waiting 2 more months to begin her mental health treatment.
All right, probation. Was a MIC evaluation done or no? All right, and is she on the mental health caseload? All right, so this is what I'm going to do. And probation, are you in agreement to denying the motion? So this is what the court will do. I'll deny the motion. I think DDRF is the appropriate placement for you. Counsel, I'll set it for an update so we can see where she is in the process.
Yes, Judge.
So I'll deny the motion, alternate amend conditions to include DDRF in custody, and then we can bring this back. We'll bring it back at the end of February to see where we are.
Yes, Judge.
Yes. All right. So we'll put it for March 4th.
Yes, Judge.
All right. We're going to bring you back on March 4th to see where you are. I understand that the wait time is long. There's limited funding, and I try to get people seen as quickly as possible. So I'm going to do the best on my end to make sure that you're seen as quickly as possible.
Yes, well, is there a chance that I can maybe bond or
No.
like the I've been sitting here for 3 months. I actually called 911 because one of my, I was having a heart attack and they brought me in and said that I did not resist arrest or catch no charges or anything.
Okay. All right. So we're going to see what we're going to do. We're going to bring you back on in March and we'll see hopefully that everything will move fairly quickly.
Thank you, Judge.
Thank you.
That'd be excused.
Yes, you may be excused. Thank you so much.
While Ms. Roblo faced charges for her reckless actions, Mr. Bohr was charged with assault causing bodily injury, and it's outrageous how he still blatantly failed to comply with court-ordered programs.
All right. Are you all ready to proceed on the motion to revoke? Yes. Court is calling 2022 CR 6099, State of Texas versus Marquise. How do you pronounce your last name? Bozier. Could I have the parties announced for the record for the state?
Ashley Jones.
Defense.
Zachary Munoz.
And are you Marquise Tyree Bozier? Did you review the documents entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and state's motion to supplement pending motion to enter adjudication of guilt and revoke probation with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Are you the same Marquise Tyree Bozier who was placed on deferred adjudication in 2022 CR 6099 on December 5th, 2022 for a period of 2 years for the offense of assault bodily injury? Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor, I'm sorry, give me just one. The state is proceeding on violation of condition number 4. Would you like me to read that?
Yes.
Violation of condition number 4 on the August 9th, 2024 supplement to the motion to enter adjudication of guilt. In Bexar County, Texas, the defendant Marquise Tyree Bozier, I'm sorry, did then and there fail to report to the supervision officer as directed for the months of April, August, December of 2023 and March 2024 violation of condition.
How do you plead to that, true or not true?
And Your Honor, I do apologize. The state is going to waive that condition. I read the wrong condition.
Okay.
So the state will be proceeding on violation of condition number 14G, that on or about the 23rd day of April 2024 in Bexar County, Texas, the defendant Marquise Tyree Bozier did then and there fail to comply with the instructions of the Battering Intervention and Prevention Program, or BIP, as directed by the head or authorized personnel of that agency, in that the defendant did not provide proof of attendance in violation of condition number 14.
How do you plead to that, true or not true?
And the state will waive all remaining conditions in all supplements and original.
Any objection to the waivers?
No objection, Your Honor.
Did you understand by pleading true to violation 14G, the court could find it true, grant the motion, find you guilty, sentence you up to 1 year in the Bexar County Jail and up to a $4,000 fine? Knowing that, do you still wish to plead true to 14G? Court will find 14G true. Is there a proposed agreement?
There is, Your Honor.
Yes.
That agreement is to grant the state's motion to enter adjudication of guilt, adjudicate the defendant guilty, and sentence him to 237 days in the Bexar County Jail. That would be a JSAT, and we would ask that time and money.
All right. What has he done on probation?
Your Honor, my understanding is he did complete some of the courses. And he did pay some of the fines and fees.
Did he complete anything? Did he complete the batterers intervention
No,
program?
Your Honor, that's why he pled true to that one. He enrolled, unfortunately, as of course well aware, it's quite time consuming and it's quite expensive in my client. Unfortunately, he has a wife and stepchildren that he is the main financial provider. Unfortunately, his wife came down with an illness to where she was unable to work, so he was.
Is there
the
any
main
proof
financial
of that?
provider. I don't have the proof for today, Your Honor.
Did he
But we
tell
are asking-
probation that he was having these issues?
I'm not aware if it's not notated in the.
Did you you want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Marquise Bozier.
All right, did you tell probation you were having difficulties? Did you tell them about issues concerning, is this your wife?
Yes, ma'am.
Did you tell them about that?
No, ma'am.
Okay. Did you complete anything on probation?
I believe it was, I had 2 courses. The BIP was the only one that I didn't complete, but everything else I completed.
All right, so you completed the DOEP course? All right, the main course is the BIP, because that's the battery intervention course.
Yes, Your Honor. No, we understand, and that is why, he has been in custody for 237 days. That's why we're asking. If pled true to that violation, we're asking the court to accept that, the current agreement of 237 days and hold that as a judgment satisfied for this case.
All right, and who is the,
The complainant is an ex-girlfriend from years ago, back in 2022 or earlier.
so has he had contact with her?
I've spoken with him prior, and no, he has not. He can go on the record, of course, and testify saying that as well.
And Your Honor, just to clarify for the record, I just want to make something correct for the record. At least in one of the supplementals, it does allege that there is a violation for not completing the supplemental, for not completing the drug course. That is an allegation that the state is waiving.
Okay.
But I just wanted to have that in front of you.
All right, the court is going to grant the motion, find you guilty, revoke. There's an affirmative finding of family violence. There's to be no contact with the complainant. That's Danesha Gray, Danesha. There's going to be credit for any time served. The court will sentence you to 1 year in the Bexar County Jail. All right, did you review the document? And the court will not do a fine. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, did you review that document with your attorney?
Yes, ma'am.
Did you understand it and sign it?
Yes, ma'am.
You have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. Because this is a conviction with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
You're welcome.
It's outrageous how some people continuously disregard the law and court orders as if the rules don't apply to them. Here's Mr. Michael back in court after violating probation by tampering with his GPS monitor.
On Michael Mora. Michael Mora? Where's Michael Mora? Come down, please. Court is calling 2024 CR 6575 State versus Michael John Mora. Can I have parties announced for the record for the state?
Megan Galloway from the state.
Defense?
David Andre Woodard from Mr. Mora.
And are you Michael John Mora? All right, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it? Are you the same Michael John Moore who was placed on deferred adjudication in 2024 CR 6575 for the, sorry, just 1 second off the record. Excuse me. You need to whisper and the deputy will move you all down to the end so you can speak. You're welcome. All right. Are you the same Michael John Moore who's placed on deferred adjudication in 2024 CR 6575 for the offense of theft $30,000 to $150,000 on June 10th, 2024 for a period of 10 years? Is that you? All right, state.
Your Honor, we're going to proceed on violation of condition number 1 on or about the 3rd day of July 2024 in Bexar County, Texas. The defendant, Michael John Mora, committed the offense of tampering with electronic monitoring device in violation of condition number 1.
How do you plead to that? True or not true?
Leave and abandon the remainder.
Any objections?
No objection, Judge.
All right, did you understand by pleading true to violation of condition number 1, the court could find it to grant the motion and sentence you up to 10 years in prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 1? Court will find violation of condition number 1 true. Is there a proposed agreement?
There is, Your Honor. It's for the court to grant the state's motion, revoke or adjudicate the defendant, revoke his community supervision, and sentence him to 4 years and TDC.
All right. What has he done on probation?
I don't think he's done much of anything, Judge.
All right, and this tampering with the, I'm assuming tampering with the GPS, what does that mean? Did he remove his GPS?
He cut the GPS monitor off.
Okay. Court is going to grant the motion, find you guilty, revoke. Probation, has he done anything?
Judge, Mr. Moore was in felony, he was a felony drug court participant at one point. Based on the court's summary, Judge, Mr. Moore did not do very much on his probation.
All right, have you done anything on probation? You want to raise your right hand for me? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God? You can lower your hand, state your name for the record. All right, did you do anything on probation? Why not?
Wrong decisions.
All right. Court is going to find you guilty, revoke, sentence you to 8 years in the prison, give you credit for any time served. There's to be restitution to Neri, Nerry, David, middle name Nuangile, last name Bumba, and Marisol Martinez. And the restitution to Marisol Martinez is in cause number 2024 CR 3664. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
No.
All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney, and the court will suggest a therapeutic community. That doesn't increase the length of time that you're in custody. However, I have no jurisdiction to force them to place you in that program. But if you request it, they'll see that I've requested it for you and they may place you in the program. Good luck to you.
Thank you.
You're welcome.
Just like in Mr. Michael's case, this time it's Mr. Ortiz, requesting leniency after being caught in possession of hard drugs while still on probation.
All right, court is calling 2021 CR 5898, State of Texas versus Richard Ortiz Jr. Can I have parties announced for the record for the state?
Megan Galloway for the state.
Defense?
Michael DeLeon for Mr. Ortiz.
Are you Mr. Ortiz?
Yes.
Did you review the documents entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amended Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Richard Ortiz Jr. who was placed on deferred adjudication for the offense of possession of a controlled substance, penalty group 1 to 4 grams on August 29, 2022 for a period of 2 years? Is that you?
Yes, Your Honor.
All right, state.
We wish to proceed on violation of condition number 1 on or about the 23rd day of November, 2024 in Bexar County, Texas. The defendant, Richard Ortiz Jr., committed the offense of possessing controlled substance in violation of condition number 1.
How do you plead to that? True or not true?
True.
Leave and abandon the remainders, Your Honor.
Any objection?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 1? Court will find violation of condition number 1 true. Is there a proposed agreement?
There is, Your Honor. It is for the court to grant the state's motion, adjudicate the defendant guilty, revoke his community supervision, and sentence him to 3 years and TUC.
All right. So has he done anything on probation?
He's done a lot, Your Honor. He was successful in safety. Yeah, he's got 401 days of credit. He was doing wonderfully, Judge, until in November, there was a incident where he in a vehicle with another individual, where the police pulled him over and he was caught with one little, what was it? Less than a gram of meth, Your Honor.
See, here's the thing. You have to change people, places, and things.
Yes, sir.
And anybody who is not helping you with your sobriety, then you got to cut them loose. All right.
Judge, additionally, he has tested clean 9 different times in a row. In 2024, he was doing pretty well overall. So we'd ask the court to go along with the plea recommendation.
All right. And did you turn over the,
I haven't, Judge. I
Oh, thank
didn't
you.
have the cause number in front of me.
oh, I'll put
I
the.
apologize.
All right. Are you asking the court to follow this agreement?
Yes, Your Honor.
Are you waiving your right to appeal?
Yes, Your Honor.
All right, then the court will follow your agreement. The court will grant the motion. The court will find you guilty. Court will sentence you to 3 years in the prison. Give you credit for any time served, credit for any inpatient treatment in the therapeutic community. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? Right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right. Here's the thing. I wish, things would have been different for you. Although my grandmother always said, never use the word wish. I hoped that you would do better. You still have a chance to maintain your sobriety and get everything on track when you're released from custody. Immediately when you're released from custody, you need to find a sober support group so that you can stay on your mission. Because once people go to the jail or go to the prison, they say, when I get out of here, I'm going to do A, B, and C. But for you, you got to have a plan and you got to stick to it. When you're released, if you can't find a specific place to go, you can always come back here. If I'm still here, I'll help you find a place.
Thank you so much, man. I appreciate you.
All right. Thank you. Have a great one.
You did.
All right. Thank you.
Finally, this last case centers on Mr. Michael EU, who faced charges of assaulting a process server.
Court is calling 2024 CR 007543, State of Texas versus Michael EU. Could I have parties announce record for the state? Defense
Tony Hernandez on behalf of Mr. Ugu.
and probation. This is an application. Thank you. Counsel, have you received all discovery? Did you review it with your client?
I have been.
Court will find that the state is in compliance with discovery. Mr. EU, did you review the document entitled Application for Deferred Adjudication with your attorney? Did you understand it and sign it?
Yes.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor, and I believe there's a trial amendment on the indictment.
Right, state, are you proceeding on the indictment as presented?
No, Your Honor. State moves to amend the indictment to change the spelling of Mr. Wu's last name from UEWU to UGWU.
Any
No
objections?
objection,
Sir, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? All right, you're charged with assault on a process server. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea you were giving up those rights?
Yes.
Did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand that the court were to grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to $10,000 fine?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Ego, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promise you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at 4 years in the prison. There's a $1,500 fine. State is silent on your application for deferred adjudication. The state recommends community supervision. There's to be restitution of $250 to Beatrice Valdez. Did you understand that to be the plea?
Yes, Judge.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Judge.
Did you understand by citing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Judge.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your deferred adjudication be for a term of 4 years and there be no contact with the complainant. Did you understand that is recommendation from the state and the court does not have to follow that recommendation?
Yes, Judge.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Containing Exhibit 1 and attachments, Your Honor.
No objection, Your Honor.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Judge.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, Judge.
Did you understand that today the state will present evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony. Did you understand?
Yes, Judge.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you applied for deferred adjudication. Counsel, do you wish to proceed with sentencing?
We can, Your Honor.
All right. Does your client have any criminal history?
He does, Your Honor. He's currently on deferred adjudication for an aggravated assault with a deadly weapon. The court granted his application for deferred adjudication. He seems to be doing very well on deferred adjudication. My understanding is he's finished the classes he's supposed to have done. He is behind on his fees, but it's been challenging for him to find jobs. But other than that, he's doing very well. He reports no UA problems or anything like that. He's doing quite well. This particular case predates the granting of the deferred adjudication on the other case, and it was, I guess, sealed for some reason because we didn't see it and the state didn't see it either.
Okay. All right. That explains things. All right. Anything states you're silent on his application for deferred adjudication, so you're excused.
Thank you, Your Honor.
You're welcome. All right. This is what the court will do. The court will sentence you to 5 years deferred adjudication. There's to be a $1,500 fine. That will be probated. Anger management, proof of employment within 30 days, no employment as a home health care provider or with minors, restitution of $250, and no contact with the complainant, Beatrice Valdez, regular reporting by Zoom or in person, regular random UAs, field visits 1 time per month for 3 months, 200 hours of community service restitution. Probation, is there anything else? Is there anything else you need from the court to be successful?
I believe he already took the anger management class under the other probation.
He'll need to speak with probation. If that's been completed, then the court will deem it satisfied because this case predates the probation case.
And just one question, is the additional community service hours, is that in addition to what he's already been given? Is
Yes.
that concurrent?
That's in addition.
That was,
And if he wishes to pay off the community service hours, he can pay off the community service hours at $7.25 per hour.
Thank you, Judge.
and Judge, that was 200 hours?
Yes.
Thank you.
All right, I'm showing you what's entitled trial, excuse me.
I'm sorry, Judge, I thought we were.
No.
I'm sorry.
Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it and sign it?
Yes, Judge.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Judge.
All right, we can go off the record. Here's the thing, when somebody comes to serve you papers, everybody's trying to do their job. This is what you can do. You can they'll put the papers in the door, or either you can tear it up after they leave, but you can't put your hands on anybody. You understand?
Yes, Judge.
All right, good luck.
Thank you very much.